All right, well, let's go ahead and get started. So, thank you again for being here today. We appreciate you taking this time. My name is Victoria. For those of you who don't know me, I'm one of the attorneys with the Copenbarger law firm. We're joined today by Charles Sosa from Lifestyle Financial Services. One of the reasons that we do these joint webinars is it is so imperative to make sure when you're thinking about your plan, whether that be an estate plan, a financial plan, whatever that plan is, that those things are working together. A lot of times, what we find is if you have an estate planning attorney who's unwilling to work with your financial planner, or a financial planner who's unwilling to work with your estate planner, something is being missed. The two have to work in conjunction because they overlap significantly, whether that be for you during your life or even for what needs to happen after you are gone. So, what we want to help address today is, are you meeting the goals that you set at the beginning of the year? As we go past tax season, as we hit that mid year point, what do we need to focus on for the next 6 months of time to make sure that your goals are met and things are properly protected and accounted for? So, we're going to go through a decent amount of information. One thing we always recommend is take notes, because if you have not seen us already this year, by attending today, this does entitle you to a free consultation with both Copenbarger and Lifestyle. So, those notes often can help flag what were the things that stood out to you today that need to be addressed in a more one on one consultation. Now, we do want to make it clear that our webinars are for educational purposes. It is so important to make sure that you take this information and come and speak with us about how it applies to you directly. It's not something that not every issue today will apply to every person, and some of the issues may apply to each of you differently. So, again, we want to implore that truly, if anything stands out, come in and take advantage of that consultation time. Now, if you don't know Copenbarger, it's been a while since you have met with us. One of the things we always want to emphasize is that we don't just do estate planning here at the law firm. Yes, estate planning is a foundational and fundamental part of what we do to help ensure that you're protected, your family is protected, and your assets are protected. But that's not always enough for what somebody needs. We have many clients who have rental properties. They may have their own business. They have additional questions that go beyond estate planning. And so that is where our business and tax department steps in. We also know that at some point we all pass away. And so we also have our estate administration department, which is there to step in and ensure that your wishes are actually carried out, that things are done accordingly, and that everybody is served in the best way possible. That can be taking things off of a trustee's plate, helping ensure that beneficiaries really are receiving what you had set out for them, whatever that may be. A lot of what we do is talking about how to avoid court, but unfortunately, in certain circumstances, court becomes inevitable for one reason or another. And so, if that does end up being the circumstance that your estate falls in or your family falls in, we also have our estate litigation department to help ensure that people don't need to go try to find new attorneys for each of these different phases or processes. We're able to handle all of this in house. But we could not do what we do without our incredible staff. So we have one of the largest staffs for this type of law, which allows us to serve more people more efficiently. So if you work with our attorneys, you are very likely going to have at least a handful of people on your team in the background, making sure things are done right and, again, efficiently. We have offices all over the state, but we know that for some people, they've moved out of state or they've moved out of one of our physical areas. And so if you can't meet with us in one of these physical office locations, we can also do things via Zoom or over the phone. So we're very accessible to our clients and to those who are seeing if we're the right firm for them. So let's jump in. So, this first part is really going to go over some of the basic foundations of estate planning. This is not only important for those of you who may not have an estate plan yet, but it's also important for those of you who do to have a refresher on why these documents are important, but also why it's imperative to keep them updated. One of the things with estate planning and financial planning is it's not a one-stop shop. And by that, I mean you don't do it one time and then set it down forever. You want to keep revisiting it to make sure it is still accomplishing the goals and your plan is still accomplishing the goals that you actually intend for it to do. So let's jump into the first one. Your Advanced Healthcare Directive. So this is the document that as soon as you turned 18, you needed to have in place. And the reason is after 18, nobody has an automatic right to make medical decisions for you if you are unable to do so. So parents lose that right, kids don't have the right for their parents, spouses don't even have an automatic right. So, what that means is if you are in a vulnerable state where you can no longer verbally communicate who can advocate for you and what they can advocate, you need to have it in writing. Now, you also want to make sure you have a more comprehensive healthcare directive. Unfortunately, for estate planning, you can find free and cheap plans all over the internet. But the less expensive, frankly, it means that quality has been cut out. One of the biggest gifts that you can frankly give to somebody who you have put in the directive or as the medical power of attorney position is to have some of those fundamental questions answered ahead of time rather than them scrambling when the time is upon them. That can be life support, organ donation. Do you want burial or cremation? These are, again, fundamental and very intimate questions that if somebody has to guess at, it can cause them a lot of guilt, anxiety, stress, added emotion, all of the things that a comprehensive healthcare directive can help cut out and allows them to advocate for you, knowing what your wishes are, and remove all of that extra emotional baggage that comes with not knowing. It's also, though, imperative to make sure you still have the right people named in the document. So this is where, again, if you haven't seen us, we say in the last 3 to 5 years, come in and let us review the documents. The reason is over the last 5 years, 10 years, 20 years, people have changed. You may not want the same people you initially named in this document to be advocating for you as you would in today's time. So again, it's important to make sure in this most vulnerable and intimate of decision-making powers, it's the right person. The final point I'll say on this is it is imperative to make sure that you have one that has been done since 2004. If you have a healthcare directive that was done before 2004, it is not valid at this point. So it is important to make sure that you, again, have it executed and updated since 2004. One thing I did not mention is if as we go along you have any questions, you need more clarification, please feel free to use the chat and the Q&A at the bottom or top of your screen. That will allow us to answer the more general questions. If things get more specific, that's where we'll encourage you to set up those private consultations. Now, with healthcare directives, if you have an existing healthcare directive that was Copenbarger prepared, you need to make sure if you have Kaiser that you come in and see us. There is new language that is specific for Kaiser for them to accept our healthcare directives that needs to be added to your existing directive. So if you have not already done the Kaiser addendum or done a new healthcare directive in the last 6 months to a year, come in and let us review and make sure that we get that language added in. Or if you're doing a new healthcare directive, great news, it will already be in there. Again, this is specific for Kaiser people. So if that's something that's of concern, let us know. The next document that is fundamental to your estate plan and to ensuring that you are protected is your durable power of attorney. Now, this is for finances. This document steps in and it comes into play when you become unable to manage your own financial means. That could be writing checks and paying bills. That could be if you now need to go into assisted living or a long-term skilled nursing plan or program and a contract needs to be signed, giving somebody the authority to do that on your behalf. This is a vital role to have established before the time of need. Because again, when you're in an incapacity situation, this is not the time you want to be scrambling. One of the things we often hear is, well, why can't my spouse just manage things? We're on the accounts together. But the problem is, if your financial advisor is managing retirement accounts on your behalf, those retirement accounts are in your name alone. Your spouse may be a beneficiary, but they have no management or use authority over that asset unless you can give your financial advisor a valid, durable power of attorney that shows you do, in fact, have that authority. So again, your spouse in particular may have access to a majority of your assets, but maybe not all of them. And the other issue is, what if you don't have a spouse or something has happened to your spouse? Truly, at that point, in most cases, you do not have somebody else who's on all of your assets. They need this power of attorney to have that authority. Now, the trigger point for when this one needs to be updated is if you have not done it within the last 5 years, you have to have these re-executed and updated. The reason is banks changed their policies after COVID to try to crack down on financial fraud and elder abuse by saying we will not accept durable powers of attorney older than 5 years because, again, they're trying to combat those issues. So it has meant that, again, clients need to make sure these are being kept up to date on a more frequent basis than was previously required. If you have any questions on when yours was executed or how to make sure it's still valid, now is the time to come in and speak with us. This next document is not applicable to everybody, but it is something that caused issues for some clients of ours about 1.5 years ago now. If you are in a position where you have a mental health condition that could lead to you being in a psychiatric health facility, so very specific level of care need at that point, and a very specific facility, they may not accept your healthcare directive as an authority for somebody to come in and advocate for you. They may require this psychiatric healthcare directive that goes above and beyond a healthcare directives, directives. This one, again, though, is very specific. It's not applicable across the board. But if you have any additional questions on that, I encourage you to come in and speak with us. Now, one of the main reasons that these two documents in particular, the healthcare directive and durable power of attorney, are so important is not only because it ensures your advocate is the right one for you and that decisions that you would want made actually get made, but the other issue is if you either don't have the documents or they're not valid and up to date and you become incapacitated, the court has to step in to appoint who can make your decisions medically and who can manage your finances. Again, most of what we talk about is avoiding court and avoiding that delay of time that becomes absolutely crucial when somebody is in a need position. Conservatorships, just to get your first hearing, can take 2 to 3 months after we have filed a petition. So what that can mean is in those 2 to 3 months, you are sitting there vulnerable because you can't advocate for yourself medically anymore, and you're not able to manage your finances. But nobody else has that authority either. So that can mean prescriptions go unfilled, doctor's appointments go missed, bills sometimes go missed. So again, having those two documents reserves and preserves dignity and ensures your wishes are carried out, but it also helps cut out the nightmare that comes from not having valid in-place documents. The next question we address is, do you need a will or do you need a trust? The only people that a will properly protect are those with no real estate or an estate less than $184,000. So if you do not fall under one of those categories, a will is not what we would suggest to set up and will not suggest setting up for you at that point. The reason is probate. So again, this is a court issue. If you own a piece of property and you have set up a will, after you pass away, the court essentially says the will didn't do enough to keep us out of the situation. Now your estate has to go through our process. Again, court is slow. It is impacted. It is not a expedient or easy process to go through. It is a legal process that is extremely time consuming and frankly, very cost consuming because probate costs about 5 to 7% of the gross estate that goes through the court. So let's take that home, for example. If you have a home that could be sold for $1 million after you pass away, they do not care what equity you have in that home. The percentage and the fee is set on the full $1 million. So if you have a mortgage, if you have other loans, if you have debts that need to be paid, you can imagine how much then that is already depleting the estate. And now on top of it, you have this additional and would have been avoidable probate fee. So again, we want to make sure that you are set up with the right estate planning documents to make sure that court does not have a chance to get involved and your estate does not get depleted unnecessarily. So that is where we talk about trusts. The whole purpose of a trust, not the whole purpose, but a main purpose is to avoid probate. But the other piece of it is to ensure that your wishes are carried out and that extra money and extra taxes and extra issues are not going to the government and can be avoided. With proper planning, that you are able to maximize your options. So, what that means is when we're concerned about property taxes or estate taxes or even capital gains taxes, by having a proper plan in place and having a trust established, we can mitigate or, in a lot of cases, eliminate taxes that would not have needed to be applicable that could be if you do not do proper planning. Now, even if you do have a trust, though, we still set up a will for you. So if you have a Copenbarger trust, you also have a will. The reason for this is when you set up a trust, you go through, you outline who would manage if you can't, you outline where will your estate go when you're gone. We answer all of those questions in your trust. And at the end of your signing, we also not encourage, we tell you to put certain assets into the name of that trust. Generally speaking, that's real property, which most of the time we're taking care of at the signing. But then we instruct you to take certain documents to your banks to put your checking accounts, savings accounts, and brokerage accounts into your trust name. Now, one of the best things you can do is to have a financial planner who understands trusts, because if you do, that step becomes extremely easy. If you have a financial planner who does not understand trusts, that step can become a lot more challenging and headache inducing. So this is again where, for this phase in particular, making sure you work with a professional who understands trusts and how they function can make your life so much smoother and ensure that things are done correctly. But we understand that sometimes assets don't get titled into the trust. That can be you have an advisor who doesn't understand the trust. That can be you forget to do it. That can be for a variety of different reasons. But if that does occur, where let's use a brokerage account, you forget to go to your advisor, or you have an advisor who doesn't understand trusts, and your brokerage account is never put into the name of the trust, and you pass away, that asset doesn't have a natural place to go, which ordinarily would mean the court gets to get involved and dictate where it goes and how it's handled. But with a Copenbarger trust, you have this thing called a pour over will, which essentially we're able to use and tell the court, no, you don't get to control what happens to it and where it goes. The person had set up a trust, so you need to give that asset back to their trust. So it is a safety net to ensure the court does not get that control or, frankly, that fee put on your asset. Now, transitioning a little bit away from the financial side of things, one of the biggest areas that often gets missed by planners who don't see the full scope of a picture. By that, I mean they don't have administration departments. They're not handling what happens when someone passes, is they miss addressing your stuff. One of the places that ends up with the worst fights, that have the worst outcomes, are the ones that have to deal with your things. It's you've passed away and now the kids are fighting over the emotional value of stuff. There's no tangible value that the court can really dictate who gets what. There's no specific item that was listed. And so who knows then, unfortunately, what the kids could fight over. But if it's addressed correctly up front, those are fights that can be avoided. So one of the things that we put in the Copenbarger Trust is a power that allows you to essentially give items ahead of time, but not have them distributed until you're gone. You are able to leave letters that say, I want my ring to go to my daughter. I want my husband's wedding band to go to my son. You can say specifically which items will go to whomever you want, whether they're in the trust or out of the trust. If you have any questions on how to do these letters, where to store them, ideas behind accomplishing those fight cuts that we're talking about, again, set up those consultations to speak with us. Now, I mentioned at the beginning that as life changes, your plans also need to be looked at. Now, that's both for the estate planning side and absolutely for the financial planning side. If you are planning to move out of, or even if you're currently out of the state planning to move into California, let's be honest, that's less likely for who we're talking to. But if you are planning a move in or out of California, it is imperative to make sure that you speak with us either before or after that move occurs. because as you're moving, you may be closing accounts and opening new ones. You might be buying and selling property. When your assets are changing, it is important to make sure that things are remaining titled correctly and that we're not, or you're not, running into any additional tax issues by shifting assets without proper planning and discussion. So this is again where, yes, talk to us on the estate planning side, but absolutely also talk to a financial planner to make sure your portfolio is still going to accomplish what your now current goals and needs will be. If when you set up your plan, you were single and now you are married, absolutely come and talk to us. That is a crucial time to come and speak with us, not only to ensure your plan still captures what your wishes are, but also to discuss additional tax benefits that you may have as a result of getting married. Married couples have significant planning options to help cut, reduce, eliminate these unnecessary taxes that can hit after you've passed away. If you got married and it's a blended family, we want to talk about options to help ensure that however that blend is, we're accomplishing the goals of both parties. So again, if you've gotten married since seeing us last, now is the time to come speak with us. Have you gotten divorced? Again, imperative time to come and talk with us. If you got divorced but don't change your healthcare directive, you could still be telling a doctor that your now ex-spouse has the right to make medical decisions for you. Or your ex could now be who inherits from you when you die, even though you have legally separated from each other. So in these life events, this again is where come and talk to your estate planner, even in the midst of either in a marriage, hopefully it's a very happy feeling, or in a divorce, even in the chaos, make sure that we are kept up to date so that we can help ensure that that new phase is still going to meet your needs. Again, though, you need your financial planner involved in both sides. If you're getting married, you now have an additional spouse and possibly additional kids that financially you want to make sure are accounted for. And if you're divorced, you may have gone from a 2-income household to a 1-income household. Again, we want to make sure that those needs are accounted and adjusted for. What about your kids? So one of the things we talk about, especially as kids become adults, is now they may have their own issues in life. By that, I mean, what if they get married and then subsequently divorced? Or what happens if they're in a car accident and their insurance won't cover the full amount? One of the things we discuss is once a child receives their inheritance, do you want it to have protection around it? And if your answer is yes, we can discuss setting up what are called protective lifetime trusts. These trusts essentially allow you to protect an inheritance for your child from outside predators to ensure that the money stays in your family and ultimately transfers, if you want it to, down to grandchildren, rather than going to a divorced spouse or to a car accident lawsuit or to any of the myriad of things that look to take an estate away from somebody. So if you are concerned about protecting that inheritance and have not already set up one of those lifetime trusts, or you're not sure if you have, again, come and speak with us. Now, one of the things you'll notice on this screen and on a number of them is there is a QR code. So for some of these topics in the webinars, we're not going to get as deep into that specific topic. But if you do want additional information, please utilize the QR codes to go to a webinar and to education material that will address these topics more specifically. Special needs kids and beneficiaries are one of the topics we're very passionate about because it is often a very misunderstood category when it comes to, can I leave an inheritance for this person who is on government benefits? The great thing is with proper planning, you can absolutely leave resources for that person without causing them to lose their benefits. But it does have to be done correctly. This is one of the most crucial points and places to not cut corners. Because you can have the best of intentions, but if you go for the cutting corners route or the cheap route, you may be defeating the exact intent and purpose that you had set out to accomplish. Again, very deep discussion that does not often apply to everybody, but if this is something that speaks to you or is something that needs to be addressed, use that QR code and reach out to us so that we can discuss it more in depth. Another piece is after you have set up your plan, changes occur. People's lives change, the people in their lives change, their assets change. There's a variety of different reasons life will make your estate plan need an update. Emailing us those changes, though, is not enough. If you email me that, hey, I need to swap my trustees, and you think that that's now going to be effective and valid, it is not. Writing all over your documents, crossing stuff out, handwriting things in, often will have the adverse effect that you expect. Not only is handwriting all over it not going to necessarily be legally valid and then upheld, it could also completely invalidate the document you had already set up. But more often than not, doing those quick changes that again are cheap and free are what land estates in court and cost in time, money, and emotion tenfold over what it would have been if it had been updated in a valid and legal way. So again, if you have changes, there are certain ones that we can instruct you to do that don't require our involvement. But for many of the things in estate planning, it seems simple. Just swap a page, just plug a new name in. But if it is not done correctly, it is, again, not valid and can lead to nightmare situations after you are gone. So you may not see the consequence, but the person left behind absolutely could and likely will. We talk a lot here at Copenbarger about legacy. So when we're discussing legacy, some of that is very on its face. We're talking about leaving financial legacies, but a lot of times it goes beyond the resource component. It goes to the relationships you want to leave and the memories. It can go to the reputation, the morals and values. Legacy has a huge component of what we do. It's the same on the financial advising side. When we're talking legacy, what does that look like for you? What do you want it to be? Again, from the financial side, that is great. That is right in our wheelhouse. It's on its face something that we can help accomplish. But for both Copenbarger and lifestyle, we go beyond that surface, easy conversation of financial resources, and we dive into what do you want left as a memory after you are gone? For a lot of people, setting up a plan that is comprehensive, effective, and makes for a much easier transition leads to more fulfilled legacies. People are left with then good memories. They're thankful things were set up ahead of time. The opposite is true when somebody does not set up a plan that makes things as easy as possible. I can unfortunately speak very personally about this. One of my relatives, after she passed, had a plan that had not been set up correctly. She had not put in enough safeguards around the specific family situation that my family would face. And it has been, we say it's the nightmare that keeps on giving. Because every time we think her estate is settled and done, something else pops its head up that needs to be addressed now 5-6 years later. So having a plan that is done correctly, and that's on the financial and planning side that I've had to deal with things not being done correctly. Every time those come up, I wish she had really sat down with a financial advisor. And at the time, it was pre me being a planner who would have helped cut out those issues, because it really does damage, unfortunately, the legacy that otherwise could have been left. So again, we implore you, work with qualified professionals who are willing to talk to each other so that everything can be accomplished in one fell swoop. Now, really quickly, I'm not going to go into these in a ton of depth because, again, these are not applicable across the board, but they are very important for you to be aware of. Legal changes can impact your estate plan, and you may not be as aware of these as the life changes. Life changes, you live. You know if you got married or divorced or if your kids became adults. But the legal changes often pass without most of our clients being aware of them. So we want to make sure you at least get a snapshot so that you know to come in and speak with us more directly if it may be applicable. The first one is Prop 19. This changed how beneficial inheriting property was for kids. Now, essentially, if a child inherits a piece of property from their parent, the property will be reassessed on a property tax basis standpoint, with one exception. If the child inherits your primary residence and claims and lives in it as their primary residence, they can still keep your property tax basis. That is the only exception. If they own it and they rent it, if they get it and they buy out their sibling, The sibling who doesn't live in there, their half just got reassessed. So this is extremely important to make sure you come in and speak with us if you are concerned about it, because we are able to add language that can help maximize the ability to keep your property tax basis if you have more than one child. But specific language has to be included in those circumstances. So again, if you are concerned about passing a property down to children and trying to keep your property tax base what you pay, come in and speak with us. Another huge change recently was to Medi-Cal qualification rules. So pre-2024, Medi-Cal, if you needed advanced care, you needed long-term skilled nursing, you needed advanced in-home care, Medi-Cal would look at what your assets were before saying whether or not you could qualify for any type of government assistance under their programs. But back in 2024, Medi-Cal eliminated the asset look and actually implemented an income look. So what that means is rather than the totality of your assets being considered for whether or not you're qualifying, they will look at your income. Now, that again has been a very fundamental change. So if you previously were denied from Medi-Cal, you may now qualify. If you're concerned about you're moving into a phase where you may need advanced care, come and talk to us so that we can discuss any pre-planning options to help protect your income. Or if you're in the circumstance of you're a caregiver and you're in a position where you're having to shell out your own money because there hadn't been enough resources, again, come and speak with us. There are significant planning options that can, in a lot of cases, help people qualify for Medi-Cal where they otherwise would not have been able to. So again, with this large change, do come and speak with us. We just did a Medi-Cal webinar about a week ago. If you want that webinar after the recording is processed, we are happy to send it to you as well. Another one that changed in the last 5 years has to do with your retirement accounts. So again, this is where having a financial advisor who keeps up to date, not only on what they need to know, but in what your estate plan laws are doing is so important. The Secure Act went into effect, as I said, about 5 years ago, and it's had modifications over the last 5 years. But the long and short of it is, after you pass away, retirement plans that transfer to essentially anybody except your spouse have to now be drawn down within 10 years following your date of death. So each beneficiary that is named on your retirement accounts has to know that they only have 10 years to withdraw funds. Now, why does this affect your estate plan? Circling back to those lifetime protective trusts that we mentioned for your children, if you have those in place and you want retirement accounts to also receive that protection after you are gone, it is imperative to make sure that the legal language in your trust complies with current laws so that you have no, well, not you, but your kids have no additional concerns or tax consequences once you are gone. Again, we're covering these quickly. If any of this is flagging, okay, I either don't fully understand it, does this apply to me, or it does apply and I need more information, take advantage of those free consultations and come in and speak with us. Now, one of the other laws that changes actually on an annual basis has to do with gifting. So every single year, thus far at least, gift tax exclusions get redetermined. Essentially, every year it goes up about $1,000. What that means is if you want to gift, you can do so as an individual to any other individual up to $19,000 without paying or having to report any sort of a gift tax. The other thing, though, with gifting is, let's say you gifted $20,000. You're 1,000 over. So what does that mean? What it means is you have to tell the IRS that you gifted in excess of the 19 by that 1,000, but you still, unless you've gone over what's called your lifetime exemption, do not need to pay any kind of a tax. You have to, again, tell the IRS that this has been done, but they deduct that excess from your lifetime exemption, which right now in 2025, your lifetime exemption is just shy of $14 million. So unless you're gifting in excess of that $19,000 per person above $14 million, you still wouldn't be paying a gift tax at that point. If you have any other questions on gifting, again, please do come and speak with us. Another one is called portability. So for married couples in particular, after a spouse passes, one of the things that gets evaluated is what was the size of your estate and what was the estate tax exemption at the point that the spouse passed away. If the exemption, so let's use today, the exemption is right at about $14 million. So let's say your spouse passes away and the estate was 10 million. Very sizable estate, but still under the exemption level. You as the surviving spouse have the option to elect for portability, which essentially means I'm going to take that unused 4 million and add it to the estate exemption I will be entitled to when I pass away. So let's say your estate doesn't move. It's still 10 million now. You pass away, but the exemption has been cut down to 9 million. Well, if you had not elected for portability, your estate would have had a 1 million excess of the exemption and then would have been subject to a federal estate tax. But because you elected to take your spouse's unused 4 from the year that they passed away, you can actually now protect, what is that, $13 million, which means your estate was 10. You are now still under the exemption because you elected again to use that unused portion. One of the reasons we bring this up is we know after a loved one passes away, one of the last things you want to do is come talk to a lawyer and deal with the legality piece. But it is so important to do so because, again, there's things that have to be done or at least considered. And if you don't consider them, you can lose the option to do so later. So that is where our administration team comes in. So like I said, that was a lot of information on the estate planning side. We're now going to transition over to the financial planning side and bring in Charles Sosa. So Lifestyle Financial, we call it our sister company. We are not directly affiliated, but the founder of Copenbarger, his wife, actually founded Lifestyle Financial about, what was it, Chaz, 30 years ago now?
Yes, 30 years ago.
All right. So Chaz is actually Laura Copenbarger's grandson. So he took over a number of years ago now and has been helping families ensure that their legacies are protected. Again, you need advisors who work with your planner. And thankfully, we have Lifestyle Financial to help ensure our clients are covered start to finish and work with us. With that, I'm going to turn it over to Chaz.
Thanks, Victoria. Well, I just wanted to say good morning and welcome. Thank you, everyone, for being here today. And it's always a pleasure to work hand in hand with Copenbarger and Copenbarger. At Lifestyle Financial, we have a simple motto, and that's a family helping families. And we mean that. We're here to work alongside you through life's biggest financial decisions, from investments to legacy planning. Today, our goal is to give you some practical insights and some things to take away and think about, no matter what stage of life that you're in. So whether you're preparing for retirement, navigating an inheritance, or simply wondering if you're on the right track, you're in the right place. Let me start by introducing who we are. So at Lifestyle Financial, our team includes myself, Zachary Raymond, who's another advisor who actually works mostly in the Bay Area, but he does come down to Orange County from time to time, as well as our office manager, Amanda Best. We each bring our own strengths, from investment strategy to personalized planning, but our focus is always the same: your goals. We are very client focused. And so we do get the question from time to time, what do you actually do? Well, we specialize in investment management to help grow and protect your wealth. But we also specialize in financial planning. So that's really important because that gives structure and confidence to your future. And so that can be everything from a very simple cash flow to a very in-depth plan that looks at across all of the main areas in financial planning. And really, I think one of our biggest strengths is just objective advice. And so we do our best to offer the most objective advice to help you navigate life's financial crossroads. Because at the end of the day, having a trusted advisor, whether it's in the legal area, whether it's in the financial area, having someone you trust is vital, especially to this process. Because if you're getting advice from someone you don't trust, you're probably not going to take the advice, and so then it's not as helpful. One study that I like to actually cite is a 2023 study by Schwab, and they said people who work with a financial planner feel more confident about their future. And that's really what we want for you. We want peace of mind and helping you create a plan that works. Here's a powerful question we like to ask. What if you could safeguard your legacy today and ensure a secure future for your loved ones tomorrow? Most of us often spend a lifetime working hard, saving, building, growing. And when it comes to legacy planning, we often delay or even financial planning. It's a good thing that you're working with Copenbarger because 67% of Americans actually don't have an estate plan in place, which, as someone who understands that area, is a little bit scary to me. And you would also be surprised how few people actually have a financial plan. And those that do have a financial plan don't always update it. And so, just as Victoria has said, it's important to keep your trust updated. It is important to update your financial plan. At Lifestyle Financial, we believe your legacy is more than just what you leave behind, but it's the impact you make while you're here. And the right planning can help you not only pass down assets, but values, vision, stability for generations to come. Now, this is a very personal process, and so this looks different for everybody. So let's talk about why financial planning really matters. I'd like everyone to ask themselves, how prepared are you to protect your hard-earned assets for the next generation, or even yourselves? Planning isn't just about accumulating wealth, but preserving assets, protecting them from things like taxes, legal risks, or financial missteps. Protecting your legacy so that way your intentions are honored. We recently had a client that together with Copenbarger we were working on, but it was really important that every year this grandfather provided for his son to have a fishing trip. And so his thing with his grandson was always going fishing. And so he wanted an investment account that would every year send his grandson um, enough money for him to be able to go on a fishing trip and remember him. And it was a really, really wonderful thing to help him plan for that. But there are just so many things that you can do. And also, crafting a strategy is important that can adapt to changing market conditions. I'm sure some people have seen the news lately, a little talk about inflation and market volatility and rising interest rates. Um, but when you have a solid plan, it not only gives you the ability to react, but more importantly, it gives you the ability to respond because you already have something in place. One key statistic is that families that pass down wealth successfully generally have three things in common. And those three factors are a written plan, regular communication, and then the education for the next generation. So that way, the next generation understands how everything's supposed to work. When's the last time you reviewed your investment portfolio? It's really easy to set it and forget it, especially when things seem to be going well. But an important thing to note is as your life changes, retirement, inheritance, health events, these are all different things that can affect your investment strategy, and you need to ensure that that evolves too. I think I may be the only person in the room who likes to look at this stuff over the weekend and ensure it's up to date, but most of us have things to do. And after a week of work or other things, it's the last thing from our minds, but time goes by quickly. And so it's really important that this is looked at. Our goal is to make sure that your investments aren't just working for you now, but they're working for you well into the future and eventually your heirs in the long run. We like to focus on active management, which means that we're constantly looking at the performance of the investments and ensuring that things are ideally situated. Clear communication. So when the markets get rough, it's always good to hear a friendly voice on the other side of the phone walking you through what's going on. And we have what we call the mosaic approach, which is just a fancy way of saying that we like to look at the full picture of your financial life, not just one account at a time. Research has shown that a properly balanced and diversified portfolio, when working with a financial planner, can outperform an emotional and reactive investing strategy by 2 to 3% over time. So that can really add up. Here's something we hear a lot. I'll get around to planning when things calm down. The truth is, life rarely calms down. I can wholeheartedly agree with that statement as someone who has 4 kids. And I think that's why planning ahead is so important. A thoughtful financial and estate plan allows you to take control of your future now, even in the midst of geographic or economic uncertainty, persistent inflation and rate hikes, or just rapid changes in the market and technology. So we help you build a plan that stands strong through all of that and also gives you options, flexibility, and protections. It also helps give you that peace of mind because at the end of the day, we want you to feel financially stable and optimistic about the future. Your future self, your future family will thank you for the decisions you make today. Financial literacy isn't just something you read in a book, it's something you live. And that's why our approach is educational, holistical, and practical. It's really important that people understand how their investments are set up, how they work, what the tax treatment is. Now, we don't expect you to be a professional, and that's certainly not the standard, but it is important to have a general idea of how all the puzzle pieces fit together. We also understand that everyone's situation is different, and because of that, we don't believe in cookie cutter situations. Everyone is unique, everyone has different goals, and everyone should be treated as such. And so if it touches money, healthcare, taxes, property, education, we're here to advise on it. One of the most fulfilling parts of this job is when some people call me and ask me, and clients, I have this situation, I have some questions. We're thinking about doing X, Y, or Z financially. We're thinking about buying a piece of property, or we're thinking about helping out our child buy their first home. You know, how much can I help them? How much should I help them? What are some things I should think about? Or even if they're just concerned. And so it's really just a good feeling when we were able to do that and provide that. But going back to your plan needs to grow with you. It needs to change with your needs and it needs to reflect your life. If you have a financial plan uh, that hasn't been updated in 10 years, it probably is not applicable anymore. It's not just your balance sheet. And so, how do we actually help clients preserve their legacy? First, we work with a long-term lens. We like to throw out the 40-year time horizon, not just 5 or 10. And that means building flexibility in your plan, regularly monitoring the progress, and making updates as life evolves. Many times we ask a lot of different questions in our meetings. What's changed since we last met? Is there anything you need to tell me? Do you have any big expenses coming up? Things like that. What's on the horizon? And the important reason we ask these questions, like, when are you ready to retire? Or are you going to sell your business? Is because they're, they're always changing. And so many times in life, when we set out to have a plan, things rarely go according to plan. And that's why we like to just keep things updated. And as things are adjusted, they can get adjusted again. Sometimes um, life events will happen, such as the buyout of a business, or a grandchild, or a change in a family dynamic, or needing to move to a different state. And so Financial planning and estate planning are not just a set it and forget it strategy. It's a living, breathing part of your financial future. And so I'll ask you, what's the financial legacy you'd like to leave behind? For some, it's about leaving enough to support future generations. For others, it's about giving back to their community or a cause they love. And for many, it's simply about knowing their family will be okay. And they did everything they could do to prepare. And so before I hand this back over to Victoria, I just wanted to cover a few things. And so, because we're at the mid-year, now is an excellent time to review your finances because it's a good point to where you can make changes, especially if you're looking to add more money into retirement accounts, if you're looking at, potential strategies on saving some taxes, deferring them. But there's other things you can do. But it is a great time to review, especially with all the things that are going on in the markets before the end of the year, because when people start talking to us in late December, it's generally too late to do anything for that year. And also, it's just good to work with financial advisors who truly understand how estate planning works, because we can look at accounts, and every month there's a couple new people that we meet with where we find out, oh, you have a trust, Mr. and Mrs. Client. So how come these assets aren't inside your trust? And they go, oh, I thought it was automatic, or I thought my other advisor did that. Many times it hasn't done. And so we help them update it. And so even if you just utilize us as a resource or a second opinion, we're always happy to work with you. There's no obligation. And, please use us as a resource. But with that being said, I'm going to turn it back over to Victoria, and thank you again.
Perfect. Thank you, Chaz, or Charles, sorry. Chaz, can you put into the chat your contact information again? I just want to make sure that everybody has it.
Yes, absolutely.
Thank you. All right. Well, as we wrap up again, we cannot implore hard enough that making sure you work with people who really are going to consider what matters most to you, it is such a vital part of the process. A lot of times, if you work with people who are trying to shuttle you in and out, where it's cheap, it's free, they're not taking the time to really sit down and look at the longevity. They're trying to, again, get you in, get you out. We're here to make sure that we walk alongside you and your families for the long haul. So we work with generations of families, both again on the estate planning and the financial planning side, because truly we want to make sure what is that longevity of legacy going to be for you and that family. Working with qualified professionals cannot be stated enough times. It really can be the make or break for, are you protected? Are your assets protected? And is your family or whoever your beneficiary is going to be, are they protected? So thank you for taking the time with us today. We are here to help whenever you are ready. We in the chat did put up a link. If you can let us know how we did today, that would be great. We really appreciate your time. I'm going to go through and answer any questions that came in during, just to make sure. Otherwise, we look forward to working with you. Thank you so much. One question that came up back at the healthcare directive about the 2004 date, California changed their HIPAA laws, so the privacy laws, and without specific language in those healthcare directives, they became invalid. So that language would only be in there post 2004. Okay. That was the only question I saw so far. We'll hang out here for another minute or so. Any other questions, let us know. And again, if you can let us know on that link how we did, that would be great. We really look forward to working with you guys and speaking soon. For how can you set up an appointment? You can call, email, visit websites, let us know, put it on the questionnaire that we put in there. But yeah, the phone number, either for Copenbarger or Lifestyle, you can call that, let them know you attended this webinar, and you would get that consultation. All right, I don't see any other questions coming in. So once again, thank you, everybody. We'll leave this up for another couple of seconds. Oh, I lied, there's one more. Oh, that's a great question. Is there any charge if you change your estate plan? So it depends on the change. Changes for estate planning, it can be a wide range of costs if there are costs associated, but at the consultation, depending on what those changes are, we'd be able to give you a precise quote for any charge that would come up. All right, we'll leave it up for another minute here. Thank you guys. Enjoy the rest of the day.